Good morning and welcome to another edition of Legal Access being brought to you by the McGuire Law Firm. And today on our panel we have three lawyers from the McGuire Law Firm as we're going to be talking about workers' compensation today. If you have any workers' comp questions, phone number is on your screen. Give us a call. Don't be shy. 843-848-8080. Here on the panel, as I mentioned, we have Ian McGuire. Also to your left, Brittany Jones. And on the end of the table, for no specific reason, Mike Smith. Hey guys, thanks for taking time out to be here today.
Yeah, it's great to be here. It's nice to have the three of us. It's usually not possible to get three of the lawyers from the office because everybody's busy doing different things. So it's just Tiffany manning the desk today. She's doing all kinds of things, mediations, depositions. But yeah, our topic today, Dave, is workers' comp. I know our firm obviously does personal injury of all different kinds. So if you want to delve away and you have a question on personal injury, feel free to give us a call. Of course, Mike's been with us for the best part of a year now, and it's been a great experience for us to have you with us. And for those of you that don't know, Mike was on the defense side for many, many years, and we were lucky enough to.
Don't need to do too much. Many years.
Well,
many
it was many years. I was right there with him, so I'm aging both of us.
3+ decades.
Yeah.
So, anyhow.
So, but we knew how great an attorney he was because we were always up against him. So it was a real coup for our firm to have him join us, and it's been everything we thought it would be. He's been fantastic. So, but Mike has a unique take now that he's on the plaintiff side, and what do you notice, Mike, as far as being a plaintiff's attorney, how it's different from the work you did as a defense attorney?
Well, the biggest change for me is just the appreciation that each individual has on being able to help them out. You know, both yesterday and today, I was able to meet with people as we were settling out cases, and you know, they're asking for you to come out and meet them and thanking you for the changes that you've made in their life and help them get over the injury perspective. And from the workers' comp, you know, personal injury from car wrecks or anything like that, we've been able to help a lot of individuals out in their struggles to get back in the saddle, so to speak. And it's just nice. It's nice to be able to have that individual communication with somebody to where you're making such a difference in their life. Whereas on the other side, when you're with the insurance company, you're dealing with one case out of hundreds and hundreds of cases. You know, I had 300+ cases at any one time that I'm defending, and it's just a number. You know, and you finish this case and then you get another one. So thank you very much, and let's move on.
Yeah.
Yeah, I saw you got a hug in the hall yesterday. You probably didn't get a whole lot of hugs from the insurance
No hugs
companies.
in the hall. Got a big handshake today, and talking about you know, welcome to America from somebody that was out of the country, and he was very pleased with the process and said, "You're our guys. You're our guys." So I said, that's nice to hear.
It is. The other day, there was a woman just sort of waiting outside the conference room, and she had tears in her eyes. So I came up. I said, "Are you okay? Is everything all right?" And it wasn't tears of frustration. Thankfully, it was tears of joy and relief. I think because she had apparently got her case resolved, and right then Mike had come out, and she gave Mike a big hug, and I was like, "Yeah, it's nice when that happens."
It is,
and you can move on. So it is. It must be a nice feeling for you to be on this side of it. And
I can pretty much count how many hugs I had as an insurance defense lawyer. So,
but it's fun being able to help people. There's no question.
Yeah.
Right.
Workers' compensation, that's our topic here today. The number's on your screen. If you have any questions, either from an employee or an employer standpoint, make sure and give us a call. We'll do our best to answer them for you here today on Legal Access. Let's go ahead and start at the beginning. As far as the process is concerned, if you're an employee and you've been hurt on the job, any kind of accident or any kind of injury, what's the first thing you need to do to, tell your employer about it?
Yeah, so just like you said, Dave,
Yeah.
you kind of gave a hint.
Sorry.
Is the very first thing that you need to do if you've been injured while you're working is to let your employer know, to give notice to your employer. in workers' comp is different than in other types of injury cases, in that your employer does get to direct your care. So they might recommend then that you go to a specific doctor or specific doctor's office to seek treatment. So absolutely, you want to let them know that the injury has taken place.
Yeah, and technically, you have 90 days to give
Right.
notice. You don't want to put yourself in a position where you haven't told anyone for the best part of 90 days. That should be really an exception. As Brittany mentioned, if the employer has a right to do an investigation and direct treatment, they want to be able to have that opportunity as soon as possible, and it's only fair. So if you're injured and you know you're injured, as Brittany said, let your employer know sooner rather than later.
Should your boss or manager then write something up and give it back to you that, Dave just told me that he hurt his back?
They're not required to do that, but certainly anytime you have a requirement to give notice, it never hurts to have that in writing, right? Then you've got a paper trail of it, and whether that's texting or even in a phone call, we have the phone records then, but it's always nice to have those things in writing.
Yeah, and the employer does eventually have to fill out what's called a 16A report once they have notice, even if they think they're denying the case or don't feel the case has validity, they still have a responsibility to fill out that 16A. And it's I think Brittany hit it on the head. Like, it's just, if there's going to be any question or any issue, having something in an email or a text is always helpful.
Typically, don't
vocalizing it.
employers have their own doctors that they want you to go see, so that if you are injured, is there a situation where you may want to go to your own family doctor, but your employer is telling you to go to the work doctor, so to speak?
Yeah, well, I'll preface what you said, but a lot of times if it's with the city or with the county, and not necessarily just Myrtle Beach, but any city or county or governmental entity, they do send the injured person to a certain doctor a lot of times. But generally, in the private sector, it's the insurance company will direct it to a doctor, and most doctors, they're really just taking the person as a patient. I know a lot of times we'll have clients that feel like, oh, they're their doctor, and they're really, these doctors are just trying to get people better for the most part. But having said that, Mike makes a great point. If there's any feeling from the individual that's injured that they want to get a second opinion, even outside of workers' comp, they absolutely can go to their own doctor and get a report, and that could be included. Usually the workers' comp in a case that's not denied is probably going to give some sort of maybe more credence to the carrier's doctor, at least at the beginning, that the person goes to, the injured person goes to.
We're going to run to a break here right now, but when we get back, we've got 20 full minutes to get you on the air and answer your questions about workers' compensation. Don't wait till the very last minute. Call us now. Numbers on your screen. We want to get you on the air and answer your questions about workers' comp here today on Legal Access, brought to you by the McGuire Law Firm. Welcome back. It's Legal Access being brought to you by the McGuire Law Firm. Today, workers' compensation is our topic, and in case you need more information, you can stop by the McGuire Law Firm office, 1600 North Oak Street in Myrtle Beach. They do have a book to tell you all the things you should do and shouldn't do as far as workers' compensation is concerned, and also personal injury. You have a book on that as well, so it's absolutely free, so stop on by and get yours today. Anytime you'd like to stop by during regular business hours. Now, Mike, you did mention that you worked for the defense on this for quite some time.
Not on workers' comp.
Oh,
That's
not on workers'
a whole
comp.
separate group of lawyers that do the defense work on workers' comp.
Well, as far as the defense is concerned, I mean, whether this is something you worked with or not, I know that pre-existing conditions come into play as far as workers' compensation is concerned. How does that work as far as either positive or negative, being able to say that, well, Dave had a back injury before he wrenched his back picking up that box over there?
You want to go?
Well, sure. I'll jump in. So for workers' comp, it's, while pre-existing conditions might come into play as they would in any case, it's not going to be the be-all, end-all. Workers' comp is a no-fault system, so just because you may have had this pre-existing condition is not going to preclude you from making a claim under workers' comp.
Yeah, if you can say it worsened your condition, even if it just accelerated your need for care that you might have needed at some point, but now you need it sooner, or just aggravated your condition, it's going to be covered under workers' comp. So it's a somewhat, I wouldn't say generous system, but it as far as proving the injury being related, a causal connection, it's definitely going to be looked at in favor of the injured person if they can just show that there's been a worsening, if there is an acceleration of need for care. So the purpose of the system is to help injured people and not really deny the cases.
And I was going off that point and just asking you guys in general, typically like in a standard personal injury case, Dave, if you've got a pre-existing condition, the lawyers will look at the medical records and see what level of pain they were in. For example, everybody's familiar with that analog scale of 0, no pain, 10 being the most pain imaginable. So you'll get a series of medical records that may have predated the accident, whether it's workers' comp or motor vehicle, slip and fall, trip and fall. And you can see the objective evidence of a worsening of a condition a lot of times by how the pain is reported. So that aggravation is something that is compensable. And you may have a series of treatments, for example, that just are related for a back problem, to steroid injections. Well, you might get into this accident and it increase your pain level to now you're needing medial branch nerve blocks and radiofrequency ablation procedures and things of that nature. That aggravation of that condition is compensable. And
kind of along the same lines, in workers' comp, one thing that comes up often is repetitive trauma. So if bending down and lifting boxes is regularly part of your job duties, and it's the fact that you've done that over and over again over a period of time, then the fact that maybe that was pre-existing or had lasted for a long time does not mean that you can't make a claim. It is still, as Mike said, compensable.
Along those same lines, a little birdie had told me one time, as far as workers' comp is concerned, that hernias are a little bit tough to prove. I mean, maybe along the same lines that they might be pre-existing.
Yeah, hernia cases under comp are very rarely do attorneys take hernia cases, just because there's no permanency to the nature of the cases. If you have a hernia surgery, you should be good to go. There shouldn't be any long-lasting negative effects. However, if you can distinguish an event that caused a hernia, it certainly should be covered under workers' comp.
And even though, Mike, you said you didn't do defense on workers' comp, from a defense standpoint, do insurance companies, do they hire private investigators to kind of follow people around to make sure that they're not mowing their yards or changing transmissions, or maybe going, surfing through social media to make sure they're not posting pictures of so-and-so kite surfing and things like that?
Absolutely, they do. One of the rare cases that I had as on the plaintiff side in a workers' comp case, I had the defense lawyer tell me that they had a video of my client catching his children as they were jumping out of the back of his pickup truck. So this is a gentleman that couldn't lift anything, couldn't get around, and of course that video was not very helpful to his case.
Yeah, in workers' comp, it's not the majority of cases, but you will have cases where they'll use an investigator. A lot of times what they end up showing on the video is really not something that the doctor says you can never do. It's just if you did it on too many occasions, it might cause more problems. So there's the occasional time where there's a smoking gun in a workers' comp, where, as Mike said, that it's just, if somebody says in a video, or in a deposition, excuse me, I can't do this, this, and this, and then they have you doing this, this, and this, that's troublesome. In the non-workers' comp cases, we rarely see that happen. The reason for that is then it'll bring insurance, because they'll say, well, who paid the money, and it's an
Exactly.
insurance company. So the defense doesn't want to have to admit in front of a jury that there's auto insurance or whatever other kind of insurance if they don't have to. So usually we don't have that problem in those cases.
No, and I've actually utilized the services of a private investigator, talked to the jury after a trial and said, you know, how effective do you believe this private investigator was? And the juror that was talking with me said, well, you know, it was a neat video, but I'm sure that you edited it to make it look good for you. We wonder about all the parts you cut out,
Right.
you know, and that kind of thing. So the juries are not, the collective group of
Right.
12 is pretty ingenious when it comes to working out issues like
Skeptical.
that.
And I think they also have a little bit of an issue and think it's a little icky or whatever, that there's somebody
Spying.
spying them,
Yeah.
and they don't, generally it's not something that seems to resonate with juries, as Mike said.
But it's something that's ironic for me. I've sat in a lot of depositions on behalf of plaintiffs in workers' compensation cases, and almost to a deposition, somebody will ask, what kind of car do you drive and what color is it? And
Yeah.
I'm thinking, okay, well, that's for, and I tell my client, yeah, they're probably going to want to put a private investigator on you at some point, and they want to know what kind of car you're driving, so be prepared for that.
Yeah.
Speaking of cars, one of the questions we get a lot with workers' compensation topics is, if I'm driving to or from work, something happens to me if I get injured, is that going to be covered under workers' compensation?
The general rule is no, it wouldn't be covered, but there's a number of exceptions to that rule. And if you have any questions, sit down with an attorney. It's not going to cost you anything, because there's absolutely an exception. If you're driving a company car, if you're doing work while you're in the vehicle, if you're making phone calls on behalf of of your employer, if the vehicle, you know, has marketing for your employer, all those are situations where it might be covered. So there are exceptions. If you're not driving, if you're driving somewhere outside of your regular workspace and then you're driving home, that might be covered. So there's exceptions. Yeah.
But if you are making phone calls, they have to be hands-free these days. Remember,
Right.
new laws just went into
right.
place. Tell you what, we're going to take another break here. When we get back, we'll have just under 10 minutes, so we still got time to get you on the air. If you have any last-minute questions about workers' compensation, call us on the number on your screen. We'll get you on, and we'll answer those questions here on Legal Access, brought to you by the McGuire Law Firm. Legal Access from the McGuire Law Firm. Today, workers' compensation is our topic. Still got a few minutes left, so if you want to give us a call, the number is on your screen there, 848-8080. We'll get you on the air and get your questions answered. What if you get hurt on the job but your boss does not have workers' compensation?
Well, then then you go through a series of tests, I suppose you'd say, to figure out if they were supposed to have it. If they have 4 or more employees, and for the most part, you need to have workers' comp insurance. I would say if you have if you have employees, even if you have 1 or 2, it's smart to have it, because if you don't and they're injured and it becomes a fault-based situation, and then you might open yourself up to an actual lawsuit. So if you can afford workers' comp, whether you have to have it or not, I would have it. But to answer your question, Dave, if your boss does not have the insurance and he's supposed to or she's supposed to, then what will happen is that there'll be insurance will come in and cover it, but that insurance will actually have a right to subrogate and try to get their money back.
Right.
Against, and it could be a lot, it could end up a lot of money if somebody has ongoing medical bills, they're out of work, they have permanent injuries. So it's really important that you get insurance. But if you were working for a subcontractor and they didn't have insurance, there's a way where you can go up and get it from the contractor. If you're a contractor, you should make sure all your subs have workers' comp insurance. So these are all things. I don't know if
Yeah,
you
well, I
want to add
was
to
just
that.
thinking, you know, we talked before about, workers' comp being no fault based, and it seems like maybe that would be better. You mentioned, Ian, that if you don't have the workers' comp in place, then it could be, just like a regular claim. Someone gets injured, it could be just a regular, almost like a premise liability claim. And that almost seems better, that it not be no fault, right? But actually that's going to open you up to all kinds of other damages that workers' comp does not normally cover. So workers' comp covers just your medical. It doesn't include things like pain and suffering, loss of enjoyment of life, all these other types of damages that get considered whenever we're looking at a regular, old premise liability case. So it would open you up to a lot of other types of damages by not having
Right.
that workers' comp coverage.
Yep.
Yeah.
Now, along the same lines, if your employer does have workers' comp insurance, but they ask you to say, hey, when you go to the hospital, don't tell them you got hurt at work. I'll pay for everything. Is that a good idea or not?
No,
No.
that's not a good idea.
I mean, anytime that you're being deceptive is
It's not a good
probably not a good idea. Not probably, it's not going to be a good idea in any case. And it really is a situation that you mentioned, Dave, where you're the reality and the practicality of it is if your boss says that to you and you don't want to lose your job,
Right.
and it's his or her word against yours, so but at the end of the day, if your injury is serious, it's important that it's documented as a workers' comp injury if it is,
Mm-hmm.
because we've seen it in the past where they're like, oh, don't worry, I'll handle it for you. And then
Yeah.
they'll handle it for a few weeks or a
Right.
few months or whatever. And then when they realize the extent of the damages, all of a sudden they're not. And then you're trying to go back and say, oh, I was just kidding. I really was hurt at work. And it makes it very difficult.
That
So
does not go well.
does not go well. So tell the truth. And if you're an employer, don't ask that of your employee, because it could come back on you in all kinds of ways that you don't want, fraud and all that stuff. So.
Tell you what, we're just about out of time. I do want to remind you once again that if you are looking for a free book, you can get one at the McGuire Law Firm offices, 1600 North Oak Street in Myrtle Beach. It tells you everything you should and should not be doing as far as workers' compensation cases are concerned. If you have any questions you weren't able to call in and ask today, you can email us as well. Our email address, legalaccess@wmbfnews.com. Next week when we get together, we'll talk about premises liability, which we talked a little about here today. Premises liability, that'll be next week. If you have any advanced questions, same email address applies, legalaccess@wmbfnews.com. And if you have any questions about workers' comp, call somebody, because consultations are free as far as workers' comp is concerned, so don't be afraid that you're going to be charged just to talk to somebody. So call up today and get the right answers. All right, next week, premises liability from the McGuire Law Firm. Ian McGuire, Brittany Jones, Mike Smith. I'm Dave Priest. We'll see you next week again here on Legal Access.
You may wish to consult a lawyer to obtain case-specific legal advice. Information regarding lawyers can be located online or by contacting the South Carolina Bar Lawyer Referral Service, toll-free at 1-800-868-2284. If you are currently represented